All right, everyone. So I know a few of you haven't been able to come to some of the classes. So what's great about this particular week is that you don't really need to know the last stuff from the past couple of weeks because it's kind of its own independent thing. We're going to kind of cover some laws and some compliance rules that are out there in the world and things that you should be aware of. They may not all affect our current industry, but they do affect several industries out there, and it'd be beneficial for you to know them. One, for the test if you ever do want to take it, and two, just in general, when you're having conversation with people, you'll know what they're talking about. So we'll get started. All right, so we're going to start covering some laws. We'll get into some broader privacy laws in a little bit, both home-based here and international. So we'll get started out with some of the common things. Some of these things you're not going to see in the book, basically because they came out of my boot camp that I took, but it became simple sentences or something that would help you remember some of these things. So the first one is common law. Common law is usually based in the U.S., Canada, the U.K., Australia, New Zealand, etc. Enforcement is based on legal precedent, and this includes written laws passed by legislators, court decisions, judges' legal opinions. A judge can say this is unconstitutional. A judge has a power in the U.S. to shut down certain things, or when he says it's unconstitutional, going against the Constitution, he can overrule certain things. But if it comes down to too much, it has to go to the Supreme Court, just so you know. Criminal law, punishing behavior harmful to society, includes jail time, death, capital punishment, fines, losing certain rights as an individual. Civil law or code law is based in France, Germany, and some of the other European countries. This is enforcement of the law based on abstract rules and concepts. Examples are democracy and property protection. There's written law, of course, and academic writings on concepts of law by legal scholars. If you hold a law degree in some countries, you can write articles, and those things can be used in a court of law to throw a judgment one way or the other. Now, you have to have that designation, of course, for that to be true, but just be aware of those things. The major difference between criminal laws and civil laws is the way in which they are enforced. Usually, law enforcement authorities do not become involved in matters of civil law beyond taking action necessary to restore order. In other words, they're not going to get in dispute between you and me over a car wreck sometimes. In the city of Memphis, particularly, if we start exchanging our information prior to the police officer arriving, they will not do anything whatsoever. They won't document it. They won't give you a traffic report on the situation or a crash report. They'll say it's an act of civil law that they won't touch. Religious laws. These are canon laws such as Vatican law, right, with Catholics, Islamic law over the Muslim religion. These things are very strongly tied to their governments, right? So I really think Islamic law is really tied more to the governments than somewhat of the Vatican law. But you will see that the government is so tied to that religion and that they've kind of intertwined it holistically throughout their entire law system. So religion is endorsed by the government, and perhaps with little or no separation between religion and state. So you will see that, like in some of these countries, to where somebody might do something that is in their religion, or do something negative that's in the religion as a state, and they would be consequent by the state or by the country based on those religious beliefs. Civil or tort law. This is also written law. Like lawsuits, punishing wrongs against individuals or businesses that result in harm. Punishments are usually financially based. Administrative regulatory law. We see these a lot, right, in our industry. Special rules that apply to particular industries. Regulators check businesses to make sure they are compliant. Administrative law is published in the Code of Federal Regulations, often referred to as the CFR. You'll see the CFR later, a little bit highlighted. Computer crimes. For classification of computer crime, computers can be a tool of a crime, such as digital manipulation, can be a target of a crime, a victim of digital manipulation, or can be an incidental to the crime, such as holding logs, right, as it says at the bottom, logs, routers, or browser cache. you can see a lot of these things, right? The hacker could use the computer to hack someone. The hacker could use a multiple of computers, such as a botnet, to act as a crime, incident there, and then can be, tracking what's going on the sidelines, and that's where the evidence comes in for number 3 there. Computer Fraud and Abuse Act of 1986, or the CFAA. This was the first major piece of cybercrime-specific legislation in the U.S. The damage threshold acknowledged under this law is $5,000, and it focuses on computers of federal interest. It covers the following: any computer used exclusively by the U.S. government, any computer used exclusively by financial institutions, any computer used by a government or a financial institution when the offense impedes the ability of the government or institution to use that system, such as a DDoS attack, any combination of computers used to commit an offense when they are not all located in the same state. This was really a groundbreaking thing for the United States of America. They really had started seeing a rise with the invention of the internet and everything else, of things coming online, and they wanted to make sure they put some sort of protection out there in their law, so that they were protected somewhat. Financial institutions, we have as a financial institution or as a bank, we have a duty to our clients, right? Some banks hold money for people, or we can hold securities for people if we self-cleared. We have that whole tie to that customer, and we always have to maintain that we can be protected and make sure we can use our systems so that our customers have available to their funds. Amendments to the CFAA were in 1994, outlawed the creation of any type of malicious code that might cause damage to a computer, such as malware, viruses, worms, you name it. They modified the CFAA to cover any computer used in interstate commerce rather than just in federal interest computer systems. So right now, they first focused on the federal machines, the financial machines. And now they're focusing on, okay, whenever things happen between states in our country, we have to make sure we have laws around that as well. Allowed for the imprisonment of offenders, regardless of whether they actually intended to cause damage. Which you see that, right? You see that, people don't always mean to. Script kiddies and stuff are playing on the internet. They're trying to just, have fun, right? They didn't mean to cause damage, but they did, and so they are held liable now. Provided legal authority for the victims of computer crimes to pursue civil action to gain injunctive relief and compensation for damages. Additional amendments were passed in 96, 01, 02, and 08. All right. Federal sentencing guidelines released in 91 provided punishment guidelines to help federal judges interpret computer crime laws. The 3 main provisions are: the guidelines formalize the prudent man rule, which requires senior executives to take personal responsibility for ensuring the due care that ordinary and prudent individuals would exercise in the same situation. All right, we've preached this before, that CEOs, board members, they are liable. Whether they own a corporation or not, while they do, they're liable if something was not done right with their security policies, with the way they acted in a current situation. They could personally be reprimanded financially for those situations, not just the business. The guidelines allowed organizations and executives to minimize punishment for infractions by demonstrating that they use due diligence in the conduct of their information security duties. Again, it comes back to due diligence, right? We got to make sure that the board, that we ourselves are having due care and doing due diligence whenever we are doing our job when it comes to security. The guidelines outline 3 burdens of proof for negligence. First, the person accused of negligence must have a legally recognized obligation. Second, the person must have failed to comply with recognized standards. Finally, there must be a causal relationship between the act of negligence and subsequent damages. Feel free to jump in if you got questions, just so you know. National Infrastructure Protection Act of 1996. All right. Congress passed yet another set of amendments to the CFA designed to further extend the protection it provides. This broadens the CFAA to cover computer systems used in international commerce in addition to systems used in interstate commerce. So, right, so we went from federal interest to interstate, and now we're going between countries, right? I think the first ones that CFAA went to was between Canada and the U.S. because it's an international boundary. So those are signs of what we're seeing the government start to take a broader stance on some of these interactions. This extends similar protection of portions of the national infrastructure other than computing systems such as railroads, gas pipelines, electric power grids, and telecommunication circuits. It's funny to me that the government realized that these systems could be attacked, so early on. Then they decided that they were going to put these protections in place. Now, these protections of the law are in place, but as we've seen, these systems are totally susceptible to hacking, right? A lot of these things have IoT devices running them or monitoring them that be taken over. I mean, there again, outside of the government side of this house, but you could look at the Home Depot situation when they got hacked, right? They had a third party come in and an IoT device that was on that. I think the HVAC system allowed these people to get in undetected and totally compromise that system and other systems below it. Treats any intentional or reckless act that causes damage to critical portions of national infrastructure as a felony, right? So this is where the government said, you know what, if you do any of this type of stuff that affects any kind of our infrastructure, period, we are going to take a serious stance on it. All right. Federal Information Security Management Act, FISMA. FISMA was passed in 2002 and requires federal agencies to implement an information security program that covers agencies' operations. FISMA also requires that the government agencies include the activities of contractors in their security management programs. Right, so we're going to get into this more in a minute, but, this is where, the government said, okay, not only do you as a federal employee have to make sure you're doing the things that are right for your information security program, but also those contractors that are very widespread. The government uses a lot of contractors to do their business. You also have to make sure that they are doing it, which enacted a lot of overhead on people. The National Institute of Standards Technology, NIST, is responsible for developing the FISMA implementation guidelines, outlines the following elements of the effective information security program: periodic risk assessments, policies and procedures that are based on risk assessments, subordinate plans for providing adequate information security for networks, facilities, information systems, or groups of information systems as appropriate, security awareness training to inform personnel, including contractors and other users of information systems that support the operations of assets of the organization. Of the information security risks associated with their activities and their responsibilities complying with organizational policy procedures designed to reduce these risks. It's a big word salad, but in the midst of the main thing is we're getting at is what I said earlier. We've got to make sure that these contractors also follow the same guidelines. So making sure they're trained as well is very important. We know of one situation where every time you visit, these people would visit a gas manufacturing facility, they had to go through and watch this 30-minute video before they did anything. Every single person, no matter who you are, no matter who you visit, if you visited before, you had to watch that video every time so that you had understanding of the security implications that were going on and the safety situations that were going on there. Periodic testing and evaluation of the effectiveness of the information security policies, procedures, practices, and security controls to be performed with a frequency depending on risk, but no less than annually. A lot of these stuff that NIST are drawing out are things that we see today, right? I mean, some of the stuff we saw on the last slide, I work through personally with the New York Department of Financial Services. You got to start out with risk assessment. Then you got to go based on that risk assessment. You got to follow that and design your plan out from there. And they got to make sure that you're following it based on what your risks are. You just don't want to just throw some random stuff out there because it's definitely not adequate in their eyes. A process for planning, implementing, and evaluating and documenting remedial action to address any deficiencies in the information security policies, procedures, practices of the organization. All right, so after we got the penetration test back, we start going through there and planning to roll out certain things to fix these gaps. So that's kind of what this is going to. procedures for detecting, reporting, and responding to security incidents. This could be, IDSs. This could be, Carbon Black, all kinds of systems that are reporting to us and telling us about possible security incidents. Office 365, and plans and procedures to ensure continuity of operations for information systems that support the operations and assets of the organization. All right, the Federal Cybersecurity Laws 2014. In 2014, President Obama signed a series of bills into law that modernized the federal government's approach to cybersecurity. The first of these was confusingly named Federal Information Systems Modernization Act, which is also FISMA. This act modified the 2002 FISMA Act by centralizing federal cybersecurity responsibilities with the Department of Homeland Security. There are two exemptions to the centralization. Defense-related cybersecurity issues remove the responsibility of the Secretary of Defense, while the Director of National Intelligence bears responsibility for intelligence-based issues. Second, Congress passed Cybersecurity Enhancement Act, which charges NIST with the responsibility for coordinating nationwide work on voluntary cybersecurity standards. NIST produces 800 series of special publications related to computer security in the federal government. NIST is the embodiment that controls all the cybersecurity rules that are out there and guidelines, best practices for the entire government. NSA, CIA, FBI, they all look in the DoD, they all look towards NIST for those best practices, and they change on an annual basis. We'll get in some of these NIST standards here in a little bit. Right now. So the NIST 800 series. So just so you know, so anything that NIST does is free to us as an American citizen. And also it can be shared outside the world with everybody else as best practices, just like any other standard can be. So you can find any of this stuff by going to NIST.gov and finding all that stuff. So the ones in particular, pertain to us are SP 800-53. Security and privacy controls for federal information systems and organizations. This standard is required for use in federal computing systems and is also commonly used in an industry cybersecurity benchmark. Out of that, when I went to that boot camp, I'd say that probably 80% of the people in there were government contractors, and they all had this whole 800.53 like blasted in their brain all these years, and that they talked about it all the time. It was crazy, but it's good that they knew that though. All right, SP 800-171, protecting controlled unclassified information in non-federal information systems and organizations. Compliance with this standard security controls, which are quite similar to those found in 800-53, is often included as a contractual requirement by the government agencies. Federal contractors must often comply with this standard. And then the NIST Cybersecurity Framework, CSF, is a set of standards designed to serve as a voluntary risk-based framework for security information systems. If you look up the CSF, the thing is massive, absolutely massive. And it's just so much detail in there, and it took people a long time to generate that data. But if you're interested, you should definitely check it out. All right, intellectual property. These are patents. Protections awarded by the government for useful, novel, and non-obvious inventions. U.S. patents last for 20 years from the date of registration filing of the patent. Trademarks. Any symbol, word, name, colors, musical tunes, or design to identify a product or service. You have to use it in commerce, in other words, in business, and continue to use it to claim it's yours. Otherwise, it doesn't expire. In other words, my personal logo that I have for my photography stuff, it's mine. I designed it. It's mine. Nobody else can use it, and I could definitely take a lawsuit if somebody tried to use that, right? Coca-Cola, right? Coca-Cola's sign is known throughout the world. The way that they have their cursive writing and everything is known throughout the world. You can't claim that to be yours by any stretch of the imagination. You don't have to file anything with the government to get that trademark, right? You create it. You know it's unique. There are trademark lawyers that go out and look for these things, but most time, as long as you're not using templated stuff, more likely it's going to be pretty original. And trademarks, by the way, are denoted with a circle with an R in them. Copyrights. Copyright protection for creative expressions of ideas, books, movies, songs, software. U.S. copyrights last for 75 years after the death of the author, right? So plagiarism is protected pretty heavily when you come down to thinking about copyright law. It's denoted by a circle with a C in it. Trade secrets. Any information, device, method, technique, or process that derives economic value from not being generally known and is kept a secret, and you must continue to protect it as a secret, right? So we'll go back to Coca-Cola, for instance. Coca-Cola, whenever they process the drink Coca-Cola, there are several ingredients in it. Well, not all of those ingredients are made in the same plant. Most of the time, when it's going to the bottling side, what happens is that all these different plants ship to this one plant for bottling, and all of the stuff is combined at that location. Nobody knows all the secrets of one piece of that formula. And that's a very good realization to think about when you're thinking about trade secrets. All right, licensing. Shrink wrap license agreements are written on the outside of software packaging. They commonly include a clause stating that you acknowledge agreement to the terms of the contract simply by breaking the shrink wrap seal on the package. You might think about this in the old days of they have CDs or DVDs, right? They used to have that thing at the top of the CD that had the license built into it. Click-through license agreement has where contract terms are either written on the software box or included in the software documentation. During the installation process, you are required to click on a button indicating that you have read the terms of the agreement and agree to abide by them. This adds an active consent to the process, ensuring that the individual is aware of the agreement's existence prior to installation. All right, we've seen this countless times in what we do, right? Cloud service license agreements take the click-through agreement to the extreme. Most cloud services do not require any form of written agreement and simply flash legal terms on the screen for your review. In some cases, they may simply provide a link to legal terms and a checkbox for users to confirm that they have read and agreed to the terms. Most users or people click their way through these things without never reading them. I heard some yesterday morning where somebody was actually getting some life insurance or whatever, or some other kind of insurance, and she was really detailed about going through the fine print. Well, she got this one part that says payout, and in that clause, what it says was, whoever is the first person to read this and call us at this number will receive $10,000. And sure enough, she received that $10,000. It happened like 2 days ago. Import and export. During the Cold War, the government developed a complex set of regulations governing the export of sensitive hardware, software products to other nations. These regulations include the management of transport data flow of new technologies, intellectual property, and PII. Until recently, it was difficult to export high-powered computers outside the U.S., except to a select handful of allied nations. The controls on exporting encryption software were even more severe, rendering it virtually impossible to export any encryption technology outside the country. Recent changes in federal policy have relaxed these restrictions and provide more open commerce. Two particular federal regulations governing imports and exports are of particular interest to cybersecurity professionals. One, the International Traffic in Arms Regulation, ITAR, control of the export of items that are specifically designed and designated as military and defense items, including technical information related to those items. The items covered under ITAR appear on a list called the United States Munitions List, USML. And here's another CFR lookup for that particular list. Number two, the Export Administration Regulations, EAR, cover a broader set of items that are designed for commercial use but may have military applications. These appear on the Commerce Control List, CCL, maintained by the U.S. Department of Commerce. More about import-export. You can export high-performance computers to virtually any country except those that pose a threat of nuclear proliferation or they have classified as a state sponsors of terrorism. These include Cuba, Iran, North Korea, Sudan, and Syria. You used to not be able to export encryption products of any kind outside the U.S. However, current regulation now designate the categories of retail and mass security market software. So let's be clear here. So if the United States, if somebody in the U.S. that is a born citizen, a citizen period, whatever, they design a new encryption algorithm, and it's put out there in the wild, right, in the world, in the U.S. for consumption, it still cannot be let go outside of the country without it, one, being not used by the government, or it still has to go through the commerce, the group of commerce to be able to go outside. The RSA encryption algorithm was just released, I think, 10 years ago outside the U.S. 3DES used to be used by the government and is no longer used by the government, so it's being declassified. So now it is able to go out there. And when I say it's being classified, that means the government stopped using it because they realized that it wasn't secure. People hacked it. They didn't think 3 rounds of DES encryption could ever be hacked. Well, it was. Privacy laws. There is no constitutional guarantee of privacy. Although several federal laws have been enacted recently, they are designed to protect the private information the government maintains about citizens, as well as key portions of private sectors such as financial, educational, and healthcare institutions, right? So the government, the U.S. government, is one of the only major countries in the world that doesn't really have a streamlined, holistic privacy, law out there, right? They're coming along with it, but Europe beat them to the punch with GDPR, and surely they're going to adopt pretty much some of the GDPR standards. We'll get into that in a little bit, though. Fourth Amendment. This prohibits the government agents from searching private property without a warrant or probable cause. This also includes wiretapping and other invasions of privacy. You're going to see as we go down this list that the Fourth Amendment was the beginning, right, where it said, okay, here's where we're going to put some wiretapping protection in. But as we get through this all the way to 2001 with the Patriot Act, you're going to see that those slowly start fading away. The Privacy Act of 1974, it mandates that agencies maintain only the records that are necessary for conducting their businesses, and that they destroy those records when they are no longer needed for legitimate function of government. It also provides a formal procedure for individuals to gain access to records the government maintains about them and to request that inaccurate records be amended. The Electronic Communications Privacy Act of 1986. This act makes it a crime to invade the electronic privacy of an individual, protects against wiretapping, email, voicemail, voice conversations, right? So as technology evolved, so did the government ruling, and that's where we saw the ECPA come in. The Communications Assistance for Law Enforcement Act of 1994, or CALI, amended ECPA in that it requires all communication carriers to make wiretaps possible for law enforcement with appropriate court order, regardless of technology in use. This created a scramble for providers, right? A lot of providers out there had no way of tapping into their customers' lines. It wasn't something they cared about. They wasn't worried about it. The government was the only one known at the time to even do those kind of things on a spy type of basis. Well, they called it out here so that if there was some sort of terrorist situation or some sort of major crime, that they could gain access to those records. The Economic Espionage Act of 1996. This extended the definition of property to include proprietary economic information so that the theft of this information can be considered industrial or corporate espionage. This changed the legal definition of theft so that it was no longer restricted to physical constraints. Right, so back in the day, everything we had was physical. Right, we had 3/4 inch floppies. We had all 5-inch floppies. We had all of these kind of physical things that data was on. But then it became over the internet. Things became readily flowing. Right, there were files that were electronic that were, now we had to adapt to those things. The Health Insurance Portability and Accountability Act of 1996, or HIPAA. You probably hear about this. You have friends in the medical field. HIPAA is a big deal, as you're going to see here in a minute. These are privacy and security regulations requiring strict security measures for hospitals, physicians, insurance companies, and other organizations that process, store private medical information about individuals. It also clearly defines the rights of individuals who are subject of medical records and requires organizations that maintain such records to disclose these rights in writing. You're going to see this every time you go to a doctor's office, right? They've got this, you're filling out your paperwork, as a new client or just updating your records, they're going to give you this privacy policy on an annual basis, usually when you go for your annual checkup. The Health Information Technology for Economic and Clinical Health Act of 2009, or HITECH. This law updated HIPAA's privacy and security requirements and was implemented through the HIPAA Omnibus Rule of 2013. This primarily changed the way the law treats business associates, right? These are people that deal with those other companies, such as hospitals, doctor's offices, etc., which are organizations that handle protected information, or PHI. Don't get there's a clear definition between PHI and PII, right? Thinking about PHI, it's only about the health records, right? Well, PII is everything else about an individual. Any relationship between a covered entity and a business associate must be governed by a written contract known as a Business Associate Agreement, or BAA. Now, business associates are directly subject to HIPAA enforcement acts. So if you say that you're a diagnostics lab for a doctor's office, right? Well, you've got information about these patients. So now, where the law before you weren't part of that, well, now you are. This required a lot of these kind of small businesses that were doing diagnostic labs or doing other things for these type of businesses. Some of them went out of business because they could not afford to put these kind of things in place. So now it's become a normal day thing. And with the invention of the cloud, also some of these things became more readily available and cheaper for these people to do business at. HITECH also introduced new data breach notification requirements. Covered entities that experience data breach must notify affected individuals of the breach and must also notify both the Secretary of Health and Human Services and the media when it affects more than 500 individuals. The Children's Online Privacy Protection Act of 1998, or COPPA, this law makes a series of demands on websites that cater to children or knowingly collect information from them. Websites must have a privacy notice that clearly states the types of information they collect and what it is used for, including if it is disclosed to third parties. Parents must be provided with the opportunity to review that information collected from their children and permanently delete it if from the site's records. Parents must give verifiable consent to the collection of information about children younger than the age of 13 prior to such collection. All right, here's another law that is definitely invoked in our business. The Gramm-Leach-Bliley Act of 1999, or GLBA, as you'll see it sometimes. GLBA relaxed regulations concerning the services that financial institutions could provide and the information they could share with each other. All of these companies must have written privacy policies and are sent to their customers. On an annual basis, our company sends these privacy notices out. It's a mailing. Sometimes the clearinghouse will send them for us, depending. It just depends. So before this act came into place, there were heavy restrictions about, certain types of investment companies talking together because of insider trading type of situations. So this relaxed a lot of the stuff so that we could open up the chains of communication and allow for more business opportunities to grow. The U.S. Patriot Act 2001, enacted in direct response to September 11th terrorist attacks. It greatly broadened the powers of law enforcement organizations and the intelligence agencies across a number of areas, including monitoring electronic communications. Right now, they can just do whatever they want to, really, if you think about it. Family Educational Rights Privacy Act, FERPA. This act deals with any educational institution that accepts any form of funding from the federal government. It grants certain privacy rights to students over the age of 18 and the parents of minor students. These are three breakdowns of the specific rulings under FERPA. Parents, students have the right to inspect any educational records maintained by the institution on the student. Parents, students have the right to request correction of records if they think are erroneous, and the right to include a statement in the records contesting anything that is not corrected. Schools may not release personal information from the student records without written consent, except under certain situations. And those certain situations are like, some sort of anonymous type of how many students passed, what the dropout rate was, those type of things. All right, more about privacy. Identity Theft and Assumption Deterrence Act of 1998. This act made identity theft a crime against person whose identity was stolen and provides severe criminal penalties for anyone found guilty of violating this law. The European Privacy Law of 1995. This directive outlined privacy measures that must be in place for protecting personal data processed by information systems. It went into effect 3 years later in 1998. It requires that all processing of personal data meet one of the following criteria: consent, contract, legal obligation, vital interest of the data subject, which is you or me, balance between the interest of data holder and the interest of the data subject. Individual rights in the law are right to access that data, right to know the data source, right to correct any accurate data, right to withhold consent to process data in some situations, and the right of legal action should these rights be violated. Even organizations based outside of Europe must consider these rules. American companies doing business in Europe can obtain protection under the Privacy Shield Agreement between Europe and the U.S. that allows the Federal Trade Commission to certify businesses that comply with regulation and offer them safe harbor from prosecution. This was invalidated in 2015 by the European Court of Justice, but was replaced and reenacted in 2016. This 9-month gap that they had really caused a strain between a lot of the businesses that did do business in Europe that were U.S. based, right? Some of them went out of business because a lot of their primary income was coming from that. But the government realized that in that 9-month window, we've got to do something. So they worked it out with Europe and finally got that corrected. To qualify for Privacy Shield protection, the companies must meet these 7 requirements for processing PI: informing individuals about data processing, providing free and accessible dispute resolution, cooperating with the Department of Commerce. That should not be marinating data integrity and purpose limitation, ensuring accountability for data transferred to third parties, transparency related to enforcement actions, ensuring commitments are kept as long as data is held. All right, here we go. GDPR, the European Union General Data Protection Regulation. This one's a fun one. This law was passed in 2016 and went into effect May 25th, 2018. It replaced the older European regulations. The major difference between GDPR and Data Protection Directive is the widened scope of regulation. This new law governs all organizations that collect data from EU residents or process that information on behalf of someone who collects it. It applies to organizations outside the EU as well. Key points to include in this: a data breach notification requirement that mandates that companies inform authorities of serious data breach within 24 hours. The problem here is, and I think this rule will eventually get changed, is that within 24 hours, majority of companies don't even know they've been breached. They have no idea. It could take 72 hours to a month. It could take a year. You never know. But I think ultimately what it wants you to know is that, whenever you find out about it, you must act with due care and make sure that they're notified as fast as possible. The creation of centralized data protection authorities in each EU member state. This was a problem when GDPR came out because every member of the EU was required to have a central office that could take on these communications and regulate these for their country and their residents. Well, a lot of countries didn't have these offices, and still to this day, some of them don't. Provisions that individuals will have access to their own data. Data portability provisions that will facilitate the transfer of personal information between service providers at the individual's request. This makes it easier so that you're not having to constantly fill out those forms, fill out all that crap. You can just ask one of the other companies you do business with to transfer that data over to the other one. The right to be forgotten. That allows people to require companies to delete their information if it is no longer needed. This is a really big situation. You're going to see this right to be forgotten all over the place. I saw a commercial when I was on the treadmill the other day at the gym. That company made a name called Right to be Forgotten, right? And it has some cool wordplay on the saying. But ultimately what this does is this allows you to, leave, say you're a credit card company. Well, you leave them, you close your account. Well, that company natively still had your data, right? They'd still house that data, and they'd still use it for statistical purposes, et cetera. Well, now you can call them up after you've done it and say, hey, I don't want you to have my information, or wipe it out of your records, right? Well, the hardest part for that company is, if they don't have everything in place, is to find all that data. Where is all that data at? Where's Aaron's information at in my database, in my files? So this required a lot of these companies to get more organized in the way that they did stuff, and also have a lot more detection on those type of files. Compliance. Now, this is probably one of the only ones you're going to see that's not a law, okay? So, but you need to be aware of it because it affects all of us. The Payment Card Industry Data Security Standard, PCI DSS. This is a compliance requirement not dictated by law, but a contractual obligation. It governs the security of credit card information and is enforced through the terms of a merchant agreement between a business that accepts credit cards and the bank that processes those credit cards. Perfect example of this is I use Square for a lot of selling my artwork to people. So Square has an agreement with Amex, Visa, MasterCard, Discover. They have an agreement in place with them that they would maintain security to certain regards that we see below in these requirements. And they have to keep those requirements up, or they'll lose their accreditation and they'll lose all their business, essentially. 12 requirements are: install and maintain a firewall configuration, protect the cardholder data. Do not use vendor-supplied defaults for system passwords and other security parameters. Protect stored cardholder data. Encrypt transmission of cardholder data across open public networks. Protect all systems against malware and regular update antivirus software programs. Develop and maintain secure systems and applications. Restrict access to cardholder data by business need to know. Identify and authenticate access to system components. Restrict physical access to cardholder data. Track and monitor all access to network resources and cardholder data. Regularly test your systems for security. Maintain a policy that addresses information security for all personnel. That's a fun one. The people I know that's in the PCI DSS world, oh my God, they say it's not so much fun, I should say, to deal with. We all know this one, SOX, right? Sarbanes-Oxley. Some organizations must ensure compliance with this ruling. The organization's financial auditors may conduct an IT controls audit designed to ensure that the information security controls for an organization's financial systems are sufficient. The expanded use of cloud service providers by many organizations requires added attention to conducting reviews of information security controls during the vendor selection process and as part of the ongoing vendor governance. All right, that's something we're really getting into too, not just in cloud side, but in third-party governance. It's something we have to do. We have to annually attest that we have talked to these companies, we have a DDQ from them or something that shows that they are doing these security requirements and that they're doing the same way we would do them or better. Sometimes you have to do physical site inspections as well. All right, everyone, that's the end of chapter 4. End of this week, and I'm going to be trying to cram at least a chapter to maybe 2 chapters in a week, so it reduces the time of this class. I know it's kind of long, but at the same time, it's the first several weeks. There's a lot of information there you got to know to even be able to proceed, and I want to make sure you have a sturdy foundation to be able to build your security posture for yourself. Anybody got any questions or thoughts?
Nope.
All right.
No, thanks,
Well, I hope
Aaron.
everyone has thank y'all. I hope y'all have a good night, and talk to you soon.
Have a good one.
Thanks, Aaron. Have a good night.
Yeah, you guys.
Multiple people are now exiting.